Any discussion about censorship at public schools must begin with the most important case on student speech rights handed down by the Supreme Court almost 4 decades ago, Tinker v. Des Moines Independent Community School District. The case began on December 16, 1965, when 13-year-old Mary Beth Tinker wore a small black armband to her 8th grade classes at Warren Harding Junior High School in Des Moines, Iowa, to protest the war in Vietnam. Over half the school day passed quietly and without incident. Just before her afternoon algebra class, Mary Beth was called down to the principal's office and ordered to remove the armband. She did so. The principal then suspended her and sent her home for violating a quickly enacted school board policy prohibiting armbands. Eventually, the school suspended a total of 5 students, including Mary Beth's brother John and a friend, Chris Eckhart, for wearing armbands to school. After the school board refused to overturn the ban on armbands, and following heated debate on both sides, Mary Beth, Chris, John, and some other students sued the school district. 4 years and 2 courts later, in 1969, the United States Supreme Court handed down its decision. By a 7-2 vote, the court ruled for the students. Yay! In a famous line from its decision, the court said that neither students nor teachers shed their constitutional rights to freedom of expression or speech at the schoolhouse gate. The court, however, recognized the unique nature of schools and the legitimate concerns of the school officials in maintaining a productive learning environment. To the extent that school officials interfered with the right of students to express themselves, the court, as it usually does in such cases, created a balancing test to analyze and weigh the competing interests. The balancing test the courts came up with, now widely referred to as the Tinker Standard, is this: students have the right to engage in free speech activities while at school as long as 1. It does not invade the rights of others, and 2. Does not create a material and substantial disruption of normal school activities. In other words, under Tinker, before school officials can censor student speech, they must first show that the speech is unlawful. For example, that it is libelous, obscene, or invades a person's legal right to privacy, etc., or that the speech would create a serious physical disruption that would prevent regular school activities from going forward. For example, an article in a school newspaper that seriously encourages students to engage in a class walkout or a school day demonstration and provides specific information regarding when, where, or how such action should occur would be considered materially disruptive and not protected under Tinker. On the other hand, Tinker's disruption standard does not prohibit speech that is merely controversial or causes hurt feelings or heated debate. The Tinker Standard, which has been applied to other kinds of student expression on campus, including student media, provides significant, though not unlimited, protection and creates a meaningful hurdle that administrators must overcome before they can legally censor. Tinker remained the sole standard for analyzing student media censorship cases for about the next 2 decades. During that time, lower courts applied the Tinker Standard to a number of situations specifically involving high school student newspapers and other student media. In most of these cases, the administrative censorship was struck down as unconstitutional. In 1988, however, the Supreme Court addressed the question it had never specifically answered before. What First Amendment protection do high school students have when working on a school-sponsored publication like a student newspaper? In the spring of 1983, students working on the Spectrum student newspaper at Hazelwood East High School, just outside St. Louis, Missouri, decided to publish a 2-page special section in their newspaper that would focus on some of the hot issues facing teens at the time. The section included 2 articles, one on teenage pregnancy and the other on the impact of divorce on students. That resulted in the principal pulling the entire section from the newspaper. The articles contained no unlawful speech, nor did school officials claim that the articles would have caused a serious physical disruption to the school day. Rather, the principal claimed he censored the articles because, among other things, he felt the topics were inappropriate for a high school audience. When neither side backed down, the students sued. After about 4 years in the lower courts, the case made its way to the U.S. Supreme Court, which handed down a decision that surprised and disappointed many First Amendment advocates. Rather than simply applying the Tinker standard to the case, which most certainly would have meant a victory for the student journalists, a 5-person majority of the justices concluded that the facts of Hazelwood were significantly different from those it had considered in Tinker. Mary Beth's armband, the court said, was private or independent speech. She made the armband and wore them all on her own. The Hazelwood Spectrum newspaper, on the other hand, was funded by the school, produced as part of a journalism class, and overseen by a journalism teacher paid by the school. It was, the court said, school-sponsored student speech, closely associated with the school itself, which the court concluded fell into a different legal category and required the application of a different legal standard. The standard announced by the court was much different from Tinker. Instead of allowing school officials to censor speech only when it was unlawful or seriously disruptive, the court said that high school officials could censor some school-sponsored student speech, including the Spectrum, when they had a reasonable educational justification for doing so. The specific phrase the court used was that censorship would be permitted where it was reasonably related to a legitimate pedagogical concern. That's obviously a much lower barrier to censorship than that established by Tinker. Predictably, Hazelwood has led to a sharp increase in the censorship of high school media. Calls to the Student Press Law Center from student journalists seeking legal help have skyrocketed, up about 350% since the decision was handed down. Those numbers continue to rise almost every year. While Hazelwood was undeniably bad news for high school student expression, there are some important exceptions to its limitations. First, Hazelwood only applies to school-sponsored speech. Independent student speech, such as a political armband like Mary Beth Tinker's, or independent or underground student publications produced by students with their own resources outside of school, continue to be protected by the higher Tinker standard. Second, Hazelwood does not apply to student media where students have been given the authority to make their own content decisions, either by a written school policy or by an established practice. Such student media organizations are considered public forums and are also protected by Tinker. Third, under Hazelwood, school officials must demonstrate that they have a reasonable educational justification for their censorship. They cannot censor something for no reason or simply because they disagree with the viewpoint it expresses. There are cases where courts have found that school officials failed to meet the Hazelwood standard. Finally, following Hazelwood, some state lawmakers concluded that the Supreme Court had gone too far in restricting the free speech of students. While states can never pass a law that provides less free speech protection than the federal First Amendment, they can always pass a law that provides more. So far, 6 states, Arkansas, California, Colorado, Iowa, Kansas, and Massachusetts, have passed so-called anti-Hazelwood laws that give back to their students much of the same protection they had under Tinker. Students in Pennsylvania and Washington may also have additional protection in the form of state regulations, and local school boards across the country, often prompted by student demands, have passed district policies limiting Administrative censorship. For more information, including sample policies and legislation, visit the Student Press Law Center website.